Hello everyone, welcome back on LegalEase. Today we are going to discuss a new topic, that is joinder of parties. Joinder of parties is given under Order 1 and majorly it is given under Order 1, Rule 1 and Rule 3. And from Rule 1 to Rule 7 of Order 1, all those provisions are related to the joinder of parties only. The conditions related to it, which is joinder of plaintiff and defendant, is given under, for plaintiff it is given under, sorry, just a minute. Yes. For plaintiff, it is given under Rule 1, and for defendant, it is given under Rule 3. So let's see, the language of both the rules of Order 1 are same. That is, Rule 1 and Rule 3 of Order 1 are language same. Just look good. Let's look at the language. So it says the joinder of the parties are possible. In case of plaintiff, joinder of plaintiff is possible and defendant is possible if any right to relief in respect of or arising out of the same act or transaction or series of act or transaction is alleged to exist in such person, whether jointly, severally, or in alternative. And the second condition is that if they bring separate suit, then common question of law or fact would arise. So what does that mean? So first of all, we have to see that the right to relief should arise out of same act or transaction or series of act or transaction. So, for example, let's say a particular right is arising out of the same contract. A contract was entered between A and B on one side and C on the other side, that A and B will provide services to C and C then will pay them money. Now, A and B performed their part of the promise, but C did not pay them the money for the services provided. So when A and B file a suit, then they can, because their right or breach of contract, that relief is arising out of the same contract, so they can join because the right to relief is arising out of the same act or transaction, that is the contract. And if they bring separate suit, then the question of law or fact that will arise will also be the same related to validity of the contract, services performed by A and B, breach by C. So that will be same. So in such cases, there is a joinder possible. So Rule 1 talks about joinder of plaintiff, whereas his right is arising out of the same act or transaction. Rule 3 is related to the defendant, wherein it says that the right against that relief is arising out of the same act and transaction. Rule 2 is same as that of the Rule 3A, which says that if the court allows joinder of parties, but then the court feels that for in interest of justice or the joinder is taking a lot of time, then the separate trials can be ordered. So even after the joinder of parties, the court can order separate trial if the court feels that it is not possible to run both the cases simultaneously and together because it wastes a lot of time. Okay, we'll discuss more examples related to the joinder. So let's take another example. There is a university wherein which conduct examination, and in for those examination um, they issue hall tickets. Now these hall tickets are issued to different students. So they denied it to 2 or 3 students on different grounds. For example, they said that one particular party, so they said that one student is not allowed the hall ticket because the student did not fill the examination fees. Okay. Another student had insufficient attendance. Another student had disciplinary proceeding. And all these students, they want to raise a complaint or file a suit against this university because all these claims are wrong, or they believe that these are wrong. So in these cases, all these of three, because it is related to the same act or series of act or transaction, can file one suit against the university wherein all of them can be joined together. Now here, when I gave you the example of contract, the causes of action for each A and B was the same. Okay, the cause of action was breach of contract arising from the same contract. While in this case, the cause of action for all of them arising are different. It is from, so for one, it is non-payment of the fees. For other, it is attendance, and the third is the disciplinary actions. So since these are three different issues, these three are different causes of action. Because it is arising out of the same act and transaction, the parties can still join, because again here the common question of law or fact will arise related to the issuance of the hall ticket by the examination committee or examination department of the university, and therefore it can be joined. So these parties can join, but when they will be joining, there will be not only a joinder of parties, but there will be joinder of causes of action also. So there is a landmark case, the name Ishwar Bhai Patel case. In this particular case, I'll give you the in the description. I've written the whole full name of this particular case. So in this particular case, the court has said that whenever there is a joinder of cause of action or joinder of parties, the other will be automatically there. So if there is joinder of parties, it's not necessary that joinder of cause of action will be there, but there are very high chances that joinder of cause of action will be there, like in this particular example. And if it is there you do not need to prove it separately. If if you want another example, I'll give you one more example. Let's say there is a company which is laying off its employees. Now the grounds of laying off are different. So for one employee, they have said that your performance is not well, or you do not attend all the meeting. ठीक है, एक को बोला है that you do not attend the meeting. Another is that you do not submit the report on time. Third one is saying that you are not good at dealing with the clients. ठीक है, इस तरह से अलग अलग reasons देके they are laying off different people. So in those cases, all the people who have been laid off can file one suit, because this is the same transaction which they are doing, and all of them say their rights are arising out of the same transaction, even if the cause of action is different, and they can together, because of the involvement of common question of law and fact, can file the suit together. But in the language that I referred, they have also talked about whether jointly, severally, or in alternative. What does that mean? So basically, all these people can be jointly liable. For example, if A and B has not performed the part of the promise and C has performed his, and C wants to file a suit against D and B. So here he can ask for the relief from A and B jointly, like both of them will give him the relief, or they are liable jointly and severally, wherein they have to give it together. Suppose it is a partnership firm, wherein all the partners are jointly and severally liable. So it can be filed when they are jointly or severally liable, or it can be filed when all the people who are joint are alternatively liable. Alternatively, in the sense, again, let's take an example. There are two friends who are flying kite, and Makar Sankranti and in different occasions or festivals, kites are flying. People, generally people fly kites. So let's say A and B are two people who have filed the kites. Just a minute. So A and B together. So this person is also flying a kite, and this person is also flying a kite. Okay. When they were flying the kite on the road, a particular car was going on, or let's say a scooter was going on, and because of the thread, this person got hurt and fell down on the road. Now, this person, when fell down the road, wants to file a suit for nuisance and negligence against these two people, but he's not sure with whose thread this accident took place. So he will join both of them in that particular suit, because he is not sure from whom he will claim the relief. He will just say that I want this particular, I'm joining the parties because I want the relief in alternative. The relief is arising out of in alternative to of the parties. ठीक है, या तो ये देगा या फिर ये देगा. So in these case also there is a possibility of joinder of parties. If we refer to the Behra Act, Rule 1, we have seen that Order 1, Rule 1, that it is talking about both the conditions. Rule 2 allow separate trial by the court. Rule 3 is the same condition as that of Rule 1, which is just for the defendant. 3 is same that of 2, which allows separate trial. Rule 4 is related to judgment against one or more joint parties. So it is not necessary, let's say on there is one plaintiff and there are defendant 1, 2, and 3. Then and they are joined together. It's not necessary that the relief will be given against all of them. The same relief will be there, or equal amount will be paid by them. It can be different amount. It can be the different liabilities as well. The plaintiff might not want anything, or the court might not give a decision against D1, but will against D2 and D3, or any permutations and combinations are possible. Similarly, if there are more than one plaintiff, it's not necessary that if plaintiff wins, then all of them will get the relief, or same relief will be got by everybody. Okay, so defendants need not to be interested in all the reliefs claimed. There can be one defendant interested in one relief or other in others. Sixth rule talks about joinder of parties liable on same contract. If there is same contract, then all the parties will be liable jointly or jointly and severally. That's also I discussed. Then seventh rule is said where the plaintiff is in doubt from whom the redress is to be sought, then he can add all the person in alternative. For that also I gave you the example of guide in this case. So these all are the different rules related to joinder of parties. In the next video, we'll discuss the misjoinder and non-joinder. I hope this joinder concept is clear to you. Please comment if there is any issue or any confusion that you want me to resolve. And stay tuned for more such videos. Thank you and have a nice day.